Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another extremely exciting episode of the Probate Realtor Show. Today, we are very fortunate. We are talking to Kevin Bayley, who is an attorney at KJM Law Partners. Kevin, welcome to the show.
Thanks, Matias. It's so great to be here. Thanks for having me.
It's so great to have you. In this show, we talk a lot about estate planning and we talk a lot about probate. And one of the things that I think we don't talk enough about is the subject matter of today's episode, which is trust administration. So, Kevin, before we get any deeper into the subject, can you give us an overview of what trust administration is?
Yeah, I'd love to. I mean, I do a little bit of planning too, and I had a 93-year-old client recently, and she was saying, well, if I die, this should happen, and if I die, this should happen, and I hope I'm that optimistic when I'm 93, but right. I'm pretty sure it's going to happen at some point for all of us. So when that day comes, I mean, a lot of the reason we do a trust is to avoid probate and avoid a long, protracted process, but of course, there is still some paperwork that needs to be done after somebody passes away, whether it's, if you have a joint trust with a spouse, if it's the first death or the second death, there is still some things that have to be done in order to, move the assets around, create subtrusts sometimes, get assets to beneficiaries at times. And so that's where the trust administration comes in. And so that's what we do. It's typically a process it's much shorter than a probate process. It's much cheaper than a probate process, but it is something people can do on their own. But basically people hire us, hire a lawyer to assist with it, because that way they are avoiding their siblings, family members yelling at them at Thanksgiving, why haven't you wrapped up mom's trust? Both this Thanksgiving or, avoiding 5 years down the road, hey, I think you did mom's trust wrong, because we do it and make sure it's done right, so that then they can pull out, well, look, you signed this that said that everything went okay because, everybody got the same thing, and you signed off that it was okay, that, Matias got the car and you got an extra $5,000. And so, let's just slow down here. So, and since we do it every day, we, know how to fill out the paperwork. We know, how to, what legally is required, and also how to deal with the institutions, that may not, what their legal requirements are. And so, we can sometimes save our clients, they don't have to be on the phone for hours with, a big bureaucratic bank who's then going to tell them, okay, this is everything we need. When it turns out, no, we can skip a couple of these steps because, what you really need is to give them these two documents, and then they'll say like, oh, okay, yeah, here.
Very nice. Thank you for sharing that with us. You said a couple of very important things during your response that I want to point out. One of them is the fact that, of course, somebody can administer their own trust, but if you want to take the steps that are necessary to avoid litigation and things like that, you can opt to have a professional do it. But something else that you said that is the fact that you do a little planning as well. And I think that's very important, because my question to you is, how is the planning process that you do prior to administering a trust informed? In other words, I guess the question should be, because you administer trusts, and so you may see what can go wrong after somebody dies, how has that impacted your way of doing the estate planning so that things don't go wrong when the trust gets activated? Does that make sense?
Sure. No, I mean, because I have, plenty of families that'll sit around the table in the conference room and they'll say, like, oh, no, it'll be fine because, my family's not about the money, it's not going to be, it's not going to be a problem. But
Right.
then I have the families that I've seen, that have come in where it's been, 2 years since parents passed away. And, one of the siblings is saying like, well, it was never, we all got along and it was never a thing. And now, I can't get my big brother to even get, talk to me on the phone. And so,
Right.
It does inform the planning because, I have people that say to me, my parents' trust was like 10 pages when they passed away 30 years ago. How come the trust you're giving me is, 40 pages, 50 pages, 60 pages? And it's like, well, like I want to protect you. I want to protect your successor trustees so that, that's what I'm here for, is to think about those negative contingencies and what can go wrong, and to plan so that, things hopefully stay amicable and there's something to point to say, no, we're going to keep things nice. We're going to play nice. And it says right there in the trust, this is what's happening.
That makes sense. Now, one of the steps of estate planning and one of the steps of when you give somebody the trust is funding the trust, right? You have the trust, doesn't mean anything if you don't fund the trust. I'm sure you guide your estate, you or somebody at your firm guides your estate planning clients into the process of funding the trust. Am I correct?
Sure. Yeah, definitely.
Great.
Detailed
However,
instructions, hold their hand, whatever's needed.
That makes perfect sense. Now, sometimes the funding of the trust, whether it's done by somebody else or something happens, and the trust and some things gets left out of the trust. So I wanted to talk to you about the Hegstead petition and what that is and how that works and why probably that's not something, it's not a DI, do it yourself kind of a thing. So let's talk about the scenario when a property or something gets left out of the trust, which should have been in. How can you help clients with that?
Exactly. You get your trust, that's great. You've signed your trust, you've done your trust. There's three important things. One, you've got to do it and sign it. Sometimes people don't come back to my office for a year because they're, and it's, they have their reasons, but, for some reason they don't want that, like putting pen to paper. Second, tell someone that you've done it so that other people know. And, I always give people a USB stick in addition to paper copies. So, share it with the important people. And then third, make sure, your stuff is actually in the trust, titled in the name of the trust.
Right.
And I mean, Matias, you're married. I assume you and your spouse have a decent estate plan. If God forbid something happens to you in a couple months, say this podcast, there are like 10 million people watch this, and your spouse comes to me and is like, he tried to answer all of them and he was at his computer for 72 hours straight and had a heart attack, and now I'm trying to figure everything out, and I found this bank account that he had, and there was it's only in his name and there was $100,000 in it.
Right.
I say, okay, $100,000, that, that's easy. We can do what's called a small estate affidavit. You wait 40 days from date of death. We do a short affidavit, get it notarized, sign it, we'll get it, moved into the trust. Now, say it's $250,000 or above. The small estate limit is about $180,000. So you go over that, you have to do what's called a Hegstead petition. It's named after there was a case, the state of Hegstead, which said, look, this person clearly meant to put all their stuff into the trust. There's language in the trust saying, I want to put stuff into the trust. There's a schedule of assets saying, here are my assets that I'm putting into the trust. There's an assignment of property saying I'm assigning all my property to the trust. They just kind of never got around to doing this, one little thing of, telling the bank, hey, this thing is part of the trust. So, let's, Your Honor, let's save your time and mine, because otherwise I'm going to come back and I'm going to have to do a probate, and I'm going to be here for the next year and a half or 2 years or so doing a probate, and you're going to tell me to come give you status reports and all that. And, so let's save everybody time and money and, just do this petition. And so we do that pretty frequently. For these bank accounts that get left out, you can do it for real property. And I mean, real property is much less common because, usually at the time you do a trust, you do the deed right in there. But
the issue with that is actually, I'm glad you're bringing that up because I'm going to talk about it. So I have encountered on several occasions the fact that the real property was originally put in the trust, then they refinanced, so they took it out of the trust, and then they never put it back.
Right.
The bank, I have this discussion in another episode. The bank doesn't care at all about your estate plan. They will tell you things that are against sometimes what you're thinking. When it comes to vesting, number one, you have to consult with the professionals like Kevin to understand. Same thing when it comes to refinance. They're going to ask you to take it out of your trust, and they may not remind you that you have to put it back in. So be careful when you refinance or do anything with the property if it was vested in a trust. So I just wanted to bring that up. Let's talk about a little bit more complex estates. Okay, so we briefly touched upon it last time we talked. You talked about international assets, and that is a very interesting thing because other countries don't recognize some of the plans that people make, et cetera, et cetera. How do you guide your clients who own property or things that are outside of the jurisdiction you work in?
Yeah, I mean, my firm, we specialize in, we have a lot of high earning, high asset, high net worth people. We do estate tax returns for folks, who are at the estate exemption level of, having 13 million per person.
Right.
As of this year, 13 million anyway. And so some of those folks have assets here and in other countries, here and in Asian countries, here and in European countries. And sometimes those countries have a common law recognition of what a trust is. Sometimes they don't. And so it's always a dance to try to figure out, how are we going to make sure that this person's desires, what they wanted to do, are carried out the way they wanted to. And so far, it hasn't been an issue actually making it happen. It's just really the key is finding good partners in those countries who can really help us, with what are the timelines like, so we can be realistic with successor trustees or administrators. What kind of documents do we need to put together? Do I need a certified document, an exemplified document, an apostilled document? Do I need all three? I mean, you're Italian, some countries want things with like a raised seal on it, and it's, got a special ribbon and all that stuff. To get through probate or to get a property transferred, you've got to do that. So we send some documents to the California Secretary of State's office, so they'll get a special stuff on it. But yeah, it's getting a good partner, on the ground there, and making sure that it's clear to everybody involved what the stakes are, so that partner also knows, hey, these are major assets and what our timelines are. I mean, we have to file an estate tax return, no matter, by the U.S. deadline, no matter what they're doing over Hong Kong or whatever.
Let's talk about that. Let's talk about the taxation of estates and exactly briefly touch upon that. As you said, your firm assists with that as well. So whether you may be directly involved in it or not, I'm sure you are familiar with the process. What are some of the, when the trust administration process gets activated, when somebody calls you and says, Kevin, I am the successor trustee and you did our estate plan, and what do I do now? So what are the first steps that you do when you start the trust administration process and somebody calls you and says, I just experienced the loss, it's time to get to settle this estate. What do we do?
Right. So there are certain things that we want to take care of right away, of, making sure that we've got an acceptance from a successor trustee to say, yes, I'm the successor trustee. This person made the trust and was the trustee. Now they passed away. I'm, taking over pursuant to this section of the trust. That way they could start going to banks, going to institutions, and saying like, hey, I need to take over on these accounts. We need to get a new EIN or TIN, taxpayer identification number. For a revocable living trust, you can use your own social security number, but once someone passes away, you can't use their social security number anymore. So a trust will need its own taxpayer identification number. We're going to right away want to do an affidavit of death of trustee and record that on any real properties that are owned, so that the assessor and recorder's office know that this person's passed away. As you know, we used to be able to pass a lot of property from parents to children. Now we can't, and yes, this is going to start the clock going on that property tax increase. But of course, they're going to find out sometime, and it's better to find out sooner rather than later and think you were trying to hide it and have them angry about that down the road. So we'll initially take those steps. If there are business entities, LLCs involved, things like that, we'll fill out other paperwork. If this is an estate that looks like it's close to the estate tax exemption amount, we'll start gathering all the information so we can determine whether that estate tax return is going to have to be filed. So that's getting appraisals on all the properties. I mean, even for a lower valued estate, you probably want to get appraisals too, just to see what your capital gains step up in basis is. But particularly important to do it quickly for those estate tax return estates to make sure we can get those.
And you can assist with all of that. Like when you guide, when you do the trust administration process, you help find an appraiser or, time of death appraisal, all of those things. You are able to guide your clients through the process.
Exactly. Yeah, we can assist with all of that. And here's an appraiser, that we worked with, or a few of them.
Right.
If you have someone you want to work with, great. Here's why, we say get a certified appraiser and not just, your cousin's boyfriend who's a realtor to give a broker's opinion of value, because, if you end up using this, the IRS is going to say, we're not going to accept that value. And then go back and forth, and we're not going to be able to close the trust and the estate as quickly. So,
yeah. That makes sense. Let me ask you a question, because I'm interested in this. When do you find yourself recommending to your clients that they select either a corporate trustee or a professional trustee rather than selecting a family member or a friend, how people do? When do you think it's advisable to select a neutral third party?
Well, I recommend it. A lot of times, if the standard for California law is that trustees need to act unanimously, or they can't act. One trustee can't act on behalf of the whole trust unless it's specified in the trust document. I have a lot of clients who they want to make all 3 kids trustees, or 4 kids trustees, and and if you really don't want to leave one of the kids out, it's better to get a professional fiduciary in there. It's better to get a corporate trustee in there, or even a family friend in that case, because and the flip side of that is that being a trustee it's not that great a job.
Right.
You have personal liability for some things. If you're the one sibling, your other siblings are kind of on your case probably, and if there are creditors out there, you can't go too fast and you can't go too slow, because you got to make sure you're paying the creditors, but your siblings want their money, so there's a dance there.
That makes sense.
Yeah, it's a tough thing, because people want their kids to be in charge, but then it's not always the greatest.
Thank you for sharing that with us. Now let's talk about your journey, because this is a particular area. So one of the questions that I like to ask is, when you were a kid, did you want to be an attorney?
I kind of thought maybe, I mean, I think in high school, I thought, maybe I would be a lawyer at some point.
Hmm.
I had a joke with one of my best friends that I had since I was 5 that we would go to the same law school, and he became an accountant and I became a lawyer. So
Okay.
I don't know which
Very
one of
nice.
us got the better part of the deal, but
Yeah, I understand. Now, let's talk about the specific area of law that you practice. When you went to law school, was it your intention when you took the wills and trust course where you're like, this is it. This is what I'm going to do.
it took me quite a journey to get to doing it. But yeah, I did when I was in law school, and when I got out of law school, I really wanted to practice trust and estate law because it is such a service area of the law. Both doing a plan. I mean, I've had couples where, they are signing their documents and then one of them says to me, like, oh, now we can go on date night again. My
Right.
spouse said to me, until we got life insurance and we signed our estate planning documents, we couldn't ride in the same car together in case something
Right.
happened.
Yeah.
And I feel like I'm giving them an actual product, whereas a lot of lawyering is, you do a lawsuit and you win, and the client feels like, well, anybody could have won because I had a great case, or, well, anyone could have got that, dismissed because they had a terrible case.
Right.
But, I'm providing something, and, you get some peace of mind, or, that your kids are going to be taken care of, whatever it is. And on the administrative side, also, I mean, these people are going through a large loss, and
Right.
and I, for better and worse, I, deal with people in that situation all the time. So, I can help it, at least this part, go more quickly, so that, or at least take this out of their hands, so that, it's not like dealing with the financial aspect is not as burdensome as the emotional aspect.
Thank you. I'm so glad you shared, your story and this information with us. This was a very useful conversation. Before I let you go, I wanted to ask, when somebody, our client, our listeners may need your services, when is the best? We'll have your contact info in the show notes, but what is the best way to get a hold of you if somebody is looking to hire an attorney?
Yeah, I'm always happy to answer emails. They can shoot me an email, kbayley@kjmlaw.com.
Perfect.
And I'll get right back to them, and happy to talk to them about any and all questions.
Wonderful. Kevin, thank you so much for your time. It's been such a pleasure to have you on the show. And thank you, everybody who has joined us for this episode. And if I don't hear from you sooner, I will see you in the next episode. Thank you. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.